Welcome to you all tonight. This is now the fourth session of the third season of the AI and the law. So thank you to Swart and to our students and to our colleagues, Prof. Sudula Kajika at the back there, Ms. Gretchen Janssen, there's Ms. Christine Strauss. Thank you for joining us this evening as well. I just want to quickly do a bit of an introduction this evening. It is my great pleasure to introduce our distinguished guest speaker, Dr. Andrew Renz. Dr. Renz is a leading expert in AI policy, data governance, and the regulation of the digital economy. He holds degrees in arts and law from the University of the Witwatersrand. We also pioneered the master's courses first taught in information technology law. With a doctorate from Duke University in North Carolina in the US of A, that's about 200 kilometers away from Kitty Hawk, where I think they sent up the first plane. The Wright brothers, focusing on copyright and educational materials. Dr. Renz has taught at WITS, UCT, and Duke in various undergraduate and postgraduate capacities. His career includes influential roles as a fellow at the Stanford Law School Center for Internet and Society between 2002 and 2009, and was the first fellow and later chief counsel to the Shuttleworth Foundation. And any of you nerds that are familiar with alternative operating systems should know something about the Shuttleworth Foundation and the role they played there. And that was from 2010 to 2022, where his work focused on reforming intellectual property law and expanding access to knowledge through various open education projects in South Africa. And he also served as a fellow at the American University's Internet Governance Lab in Washington, D.C., with a focus on the regulation of artificial intelligence and the Internet of Things. Currently, Dr. Renz conducts research at Research ICT Africa, advises as an independent technology regulation consultant, and continues as a practicing attorney. His insights into AI, digital governance, and intellectual property law are invaluable, and we are privileged to hear from him today. And if ever you needed any further affirmation of the credentials of Dr. Renz, I did inquire earlier whether Dr. Renz might be bringing his laptop, and I was told yes, he would, so that was fine. And then he got here, and I said, okay, we can just plug your laptop, and he said, oh, it's running Linux. Is that going to be a problem? The only person so far in my years at this faculty that tried to plug a Linux system into this old main building, it's just as well we didn't. Something could have gone wrong, alarms would have been sounded, the system would have collapsed, who knows? So without further ado, a warm Marty's Law welcome to Dr. Andrew Renz. This, if I can just ask for you to more or less stay in this zone.
Good. Thank you very much for this opportunity. And that should not read human rights, should be copyright and generative AI. You can see I cribbed a slide from a previous talk. So let's talk about developing an AI model. I understand that in this series, you've already had someone talk to you about the technology. Feel free to correct my simplistic understanding. I've only spent a couple of years trying to understand what the technology is talking about. So that's an ongoing project, but it's something that as technology lawyers and policy experts, we have to continually do, try and make sense of what the technology is talking about and translate that. So let's talk about the training data used to train the current frontier models, the large language models that we reference when we're currently talking about AI. Of course, it was a previous generation of AI in which computer vision was the big thing. There's been several iterations, AI winters. Long ago, there was attempts before neural nets to make AI out of writing rules. I think Pascal's theorem could have told them that would fail, but apparently they just tried anyway, and it failed. So these are the big sets that people have used to train the current generation. So books 3, which is quite a few books, ImageNet, labeled images. Ludwig Maximilians Universität München, they gathered a lot of data. They gave it to Stability AI, who in turn gave it to Stable Diffusion. So is that a data washing? We give it to someone maybe willingly because we think it's going to be used for non-profit purposes, and then lo and behold, it's used for purposes. Common crawl, so okay, no permission here, just a a web crawler copying things off the internet, including off the dark web, maybe things that are up there without copyright owners' consent. Web text 2, Wikipedia. Actually, not so obvious that you're allowed to go do that with Wikipedia, because if you reproduce it, then you're bound by the license, which in this case happens to be Creative Commons Attribution Share Alike 4.0. And that means that if you make a copy, you have to license it under the same license. And the stack, which is Hugging Face are the as good guys as you can get in the AI world, and they get permission for all of their input data. Now, I understand not everyone here has done intellectual property yet. And so I'm going to take just a moment to talk about this idea of data. You're going to have to excuse me if I say data or data. I spent a long time in the United States. Nobody understands you if you say data. So the input data is, in the world of copyright, there's two very different notions. If we had a whole lot of weather data, temperatures at different locations at different times, that is all facts. Facts on their own, each datum is what my Latin professor would have insisted. I call it data point, I guess. Data scientists would call it now. Cannot be copyright, right? The individual thing on its own. It's a fact. Facts aren't copyright. You make a big pile of these, and in South Africa, you can get copyright if there's creativity in the arrangement. In Europe, you can get that sui generis database thing that never caught on in the rest of the world, so there doesn't seem to be much point to it. And in Australia and the UK, sweat of the brow gives you something very similar to South Africa. You get a copyright right. But the input data, if it's weather data or financial data, if it's facts, isn't copyright. But that's not how LLMs see the world. For an LLM, a book or an image isn't really terribly different as an input from their perspective. So copyright lawyers be horrified at this. Because books are copyright work. Images are copyright work, usually. I mean, there are obviously things that aren't copyright because they've fallen out of copyright or because it's purely factual. So purely factual photograph, not copyright. But anything composed, anything where there's a bit of artistic intent, copyright. But from the LLM perspective, it's all just data, right? Personal facts about people. When you phoned your boyfriend, it's just data. It's just trying to build numerical tokens and feed them through the system. So the developers of AI haven't paid much attention to whether this thing is copyright, this book. They've just treated it all as data. So a fairly simple model of a neural net, we have the input layer. So we take the books or the images, and they become a set of numeric tokens. And then through a series of hidden layers, we develop weights. So how likely a token is related, or how a token is related to another token. Is it going to be in an image? Is it likely to be close to it? In text, is this likely to be the next word or the one after that, etc. Then we have the output layer. Sometimes this cleans things up. No, you're never allowed to make humans with 7 fingers. No, you can't use a sexual expletive here. So yeah, there's just a similar diagram of the same thing. We're trying to show the weights and the way you try and have some feedback with backward propagation to say, well, maybe we've put examples up, or maybe we have humans responding to the output and saying, no, bad, this good. And then you can have backward propagation where you change the weights. All right, so we got it all from scraping the internet. And so, was that okay? Was that permitted under copyright law? Well, let's talk about how the internet works, and particularly the World Wide Web works. How do you read a website? You enter well, back in the day, you typed in the address in the command line, more likely now you use a search or you use a link from another website. And what that does is it sends an instruction to your internet service provider, who sends a request to the service provider hosting the page. That service provider hosting the page makes copies that it breaks up into little packets, sends on diverse routes across the internet, that gets reassembled, usually by your ISP, and then sent, sometimes in packages again, or sometimes all at once, depending on how your ISP works. And then another copy gets made on your computer. And then, yeah, and then there's a display. So there's a set of ones and zeros on your computer. Maybe that gets turned off as soon as you leave that website. Maybe so you don't save it, but for as long as you're looking at that website or you have that tab open, which for some people can be years, close your tabs. It's there's a copy. And then there's a display copy, but there's also the ones and zeros copies that are made multiple times. And in fact, when those packets are sent through the internet, there's multiple copies being accumulated. Your ISP is keeping that copy for a while. It's caching it, because what if lots of people demand this? And if lots of people demand a particular page, then your ISP just keeps a copy all the time and checks back every now and then, see if it's changed. So it doesn't have to keep requesting it, right? Why keep schlepping something from the United States, say, when you could just have a local cache? So if you're Google, you have a local cache of your search page here in South Africa, because lots of people are going to query it all the time. If you're Harvard, you don't, right? You're going to have to ask for that from the ISP in the US. So how do you watch a YouTube video? Well, what happens is the same thing, right? It gets broken up little packets, reassembled by your ISP. And then, now sometimes there's buffering in South Africa still, and you can't get the whole thing at once, but usually it tries to, the objective is to try and give you, so the whole thing is temporarily stored on your computer. And if you use something like Download Helper, you can capture it onto your computer. So you've made multiple copies. It's really important to bear this in mind, just to watch a video. How does Google search work? Well, it makes copies of these websites. It looks who they link to, and it does PageRank. Then it does some weird proprietary stuff, which probably is to do with maximizing the advertising revenue, and we can't see what that is. But they're copying the internet all the time. And then they're discarding pages when they, old ones change, they don't keep it. But just for us to be able to find things, so should I date myself and mention what the internet was like before Google? Like, basically, you had a number of trusted websites. Oh yeah, my guys at Stanford, before I even went there, they've got a really good set of links. I'll go there and see if I can look at their links, and then from following those links, see if I can see some other links that can find this thing I think exists. Bradley. Yeah. 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 And so we had a couple of search engines, Yahoo, Alta Vista, Ask Jeeves, but really you always got a sense that, you were in a room, let's say a museum room full of artworks, and you had a feeble torch in South Africa, that got you this one half a picture here. There might be the Mona Lisa over there, you couldn't find it. Google changed that. Now, dubious about what Google has become, but we wouldn't have that level of functionality without multiple copies. This is going to matter. Okay, but before we get there, let's talk about what happens when you use those LLMs to make stuff. Some people would say more of the same stuff they've ingested. I would say that looks like or imitates the stuff they've ingested. I think there's a categorical difference, a philosophical, ontological difference, if you like. Not everyone agrees. Some people say ontologically, an image generated by DALL-E is ontologically the same as one painted by Dali. I think there's an ontological difference because I think Dali meant something. He was trying to convey a meaning, and I don't think the LLM is trying to convey a meaning, and that's not going to matter that much for copyright law. Matters a whole lot for freedom of expression, which we're not going to talk about tonight. But what happens when you make more and more stuff that looks like human stuff, and then you feed it back in to the models? Well, there is a concern, hasn't been conclusively demonstrated yet, that you will get model collapse, because you will get that little discrepancy between human creativity and LLM outputs will slowly, because you're feeding it back in recursively, slowly produce stuff that is useless to us, that is alien to us, that is got, I don't know, it's the equivalent of genetic inbreeding. It's got now too much of its own material. So that could then mean that the developers of those large language models have pulled up the ladder after them. They've used the internet to create these things, and then because these things have now polluted the origin, that there's now going to be a problem, and only, of course, the only people who are going to benefit are Pearson and the other big the Dutch Elsevier, there we go. That because they're going to have walled gardens of content, very little of which they paid for, right? So academics all gave it to them for free. It's a weird business model. Please publish my work. I will give it to you for free. Yes, so long as you also peer review some other people's work free. And then your institution will pay for accessing your work, obviously. And if you want it to be completely open, well, then you pay us again. Okay. So, but they could make a fortune because they will have clean data. So clean data could be, in a polluted world, really economically important. Some developers claim, oh, we won't get model collapse, we'll figure it out. But let's assume that there'll be model collapse. So, you know the meme, Chloe watching the house burn. 5,000 years of human knowledge and know-how, and ChatGPT is like, yeah, we'll just burn it all down. That meme is so old that she used the money for selling an NFT for this image to put herself through University of North Carolina at Chapel Hill. It's a good school. Not as good as Duke, but almost as good. No, we were basketball rivals. So how do you use generative AI? So let's see some hands, or people can call out. How do you use generative AI? Come on, everyone uses it. Or most people use it. Yes, Murray. Yeah. Come on, someone else. Students are denying they use it. You use Claude, Gemini. Oh, sorry, I mentioned ChatGPT. No, I said generative AI. Yeah, I know what I use it for. When I run angry email, then I say, okay, reword politely. It's actually a pretty good use. Like, I'm really furious. And normally I would have just had to keep it for 3 days. But no, I can send it now because it's been sanitized. All right. So now we're going to talk copyright and generative AI. So generative AI, as you probably already know, is AI that generates what I call counterfeit human communication. It's not human communication. It looks like human communication. Know, though, that there are people who will push back. They think it's just as good as. If they like a picture from Dali, it's just as good as art. Okay, we will have to disagree. So 16th century law. Why do I call copyright 16th century law? Because that's when you get the Statute of Anne, the first copyright statute. And so for those of you who are going to go to court one day as lawyers, who already do, you will don a black robe when you go to court. If you become an advocate, you'll also get this little white bib. And copyright is older than the practice in Anglophone courts of wearing those robes. That only came in when they beheaded Charles II, the the British bar were monarchists and they went into mourning and they stayed in mourning as a form of political protest. And that's what we're doing in South Africa when we wear a black robe. We're mourning Charles II, apparently. I mean, I have a black robe. I wore it in court the other day. I go to court very often, but that's what's going on. Copyright is older. Now, it has changed and adapted and evolved since then, but understand that it's a late medieval or early Renaissance invention, maybe late Renaissance, but it's a Renaissance invention. And so it's come a long way from its origins, and now it's encountering something that really wasn't even imagined 50 years ago, 20 years ago. So it creates 4 questions, which should be numbered 1 to 4, but somehow Microsoft has renumbered them. 1. So the first question, does the use of copyright works in the corpus used to develop an AI model infringe copyright in any of those works? We're going to talk about that question. Number 2, does the output of a generative AI model infringe copyright? That's the second first question. The third first question, is there copyright in an AI model? And the fourth first question is there copyright in the output of a generative AI model? We're going to answer questions 1 and 4. The answers to the other 2 are, well, number 2 is fairly easy. Well, if there is, go ahead and sue. Shouldn't be too hard, right? If you use ChatGPT and it spews out your novel, you're just in the realm of any other kind of litigation where you're trying to prove sufficient similarity, substantial part of the work. And of course, dealing with exceptions. Is there copyright in an AI model? Well, quick answer, the software is copyright, unless, of course, it's a computer-generated work, which creates a set of problems we're going to talk about in answer to the fourth question. The algorithm is not, because algorithms are not copyright. They're mathematical functions, and maths isn't copyright. So, our question. We saw books 3, we saw Common Crawl. There's a lot of copyright works. They get scraped, copied, and the question is, are they copied for the purposes of copyright? So we've got a lot of litigation going on. We've got Authors Guild versus OpenAI in New York. That was around books 3. We've got Silverman versus OpenAI. Get that court, which court that is. It's Northern District, California. Of course it is. That's on book corpus. Silverman versus Meta, also Northern California. So that's where San Francisco is. That's why the litigation's happening there. Books 3, John Doe versus GitHub and Microsoft. That's also in California. So they all want to be in the Ninth Circuit because those judges are the judges who understand technology better. Not necessarily well, but better. Nobody wants to be in the Sixth Circuit, where North Carolina was. And then Getty Images versus Stability AI is actually in the Court of Chancery in the UK. And that was based on something called Lion 5B, which was a non-profit German professor created, not the same professor as created that other thing, a non-profit image set of images and other text and other input sources. We don't have answers from any of these. They're still skirmishing. There's a lot of fighting about what's going to happen. So in terms of comparative law, we only have one case, which I haven't listed here, unofficial English translations of a case in China. The court said, oh no, sorry, that's actually the next question. Can an AI generated work be copyrighted? And in China, the court said yes. In the rest of the world, no, but we'll come to that. So copying. Section 6 of the Copyright Act first talks about the nature of copyright in literary or musical works. There's also images, which are artistic works. And it says that if you are the holder of the copyright, so either the author or a successor to the author, you have the exclusive right to do or authorize reproducing the work in any manner or form. So if I make a copy of an image, it would appear to infringe this, or would it? Because remember when we were talking about how the internet operated, we said that the internet operates by making multiple copies. So on what basis can we do that? That every time I look at a website, am I infringing? Why is the website up if I'm infringing copyright by reading it? They wanted me to read it. Is it implied permission? Is it an exception? So in the US, people would just say, it's probably fair use. We're good. But is it not a copy because it's transient? Okay. All right. So what's reproduction? So definitions tell us that reproduction in relation to a literary or musical works includes reproduction in the form of a record or a cinematographic film. So a record is an LP. Okay, does anybody not know what an LP is? It's a round black disc that you play on a player back when all media had to have a material form. So reproduction in relation to artistic work includes a three-dimensional form, or if it's in 3 dimensions, so it's a sculpture, 2-dimensional form. And it includes a reproduction made from a reproduction. That doesn't really help us with our problem around reproduction. All right, well, let's say I don't copy the image. Let's say that I have a crawler for my LLM that looks at the image and makes the tokens straight away and shoves them in a pile. Not a copy, definitely, right? Let's say I temporarily cache the image, so no longer than you reading the website on your screen, and then I tokenize it. Reproduction or not? No one wants to commit. We should have a pro-reproduction faction, anti-reproduction faction. It's clearly quite a difficult legal question, right? But let's assume that there's at least some reproduction. So remember, reproduction includes an adaptation. Back here, reproducing any manner or form. Now, an adaptation is what in the US is called a derivative work. It's you take something and change it. You take a novel and write a play. You take a novel and write a film script and make a film. You're changing it from one kind of work to another, right? You have a film and you make a computer game, which includes computer software and graphics and so on. So I'm not sure why, because you get an exclusive right to make a reproduction and you get an exclusive right to make adaptations when you're the copyright holder. Those are two separate exclusive rights, and they're two different things. Somebody copied my novel 10 times, not allowed. Somebody turned it into a play, also not allowed, but different event, right? But for reasons known only to themselves, sometime in like 1981, I think, the legislature, now they're probably dead, so we can't ask them, decided that a reproduction is also an adaptation. Whereas could have just been like, don't do reproductions, don't do adaptations. Here we are. So adaptation in relation to literary work includes, in the case of a non-dramatic work, a version which is converted into dramatic work. In the case of dramatic work, non-dramatic work. Translation, or maybe your tokenization. You could say, if you tokenize it, you're translating it into the language of an LLM, but you're turning it into maths. There's no human. So is that still translation? You're just arguing by analogy. Okay, a version of the work in which you basically use pictures. So again, 1978, right? This is pre the internet. This is pre the digital revolution. This is primarily concerned with a world in which almost all media are physical. You took the novel, you made the graphic novel. So is there infringement? And this is a separate question to whether there's reproduction. There's no infringement without reproduction. But let's assume that there's some reproduction some of the time. Is it infringing? it's not clear to me that a lot of the time there is reproduction that will trigger the Copyright Act. But let's assume that there is some of the time, right? And that we can prove it, which is another whole game. Well, maybe not. Maybe it's de minimis. It's just not that important. It's trivial. You might say, but it's my whole book. Yes, but I'm not really selling copies of your whole book. I'm turning it into a string of numbers and I'm using it to predict the next word when somebody gives a prompt. That's got nothing to do with your book. Your book is about the beautiful hikes around Stellenbosch, and it's answering somebody's prompt about, you know, where, what's going on in Bosnia. You know, it's just a tiny, 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 infinitesimally small part of this thing. That, by the way, in the Getty Images case in Chancery is the primary defense. Well, we might have used the whole work, but it's a grain of dust in this thing. So remember the adage, I'm going to expect Stellenbosch students to not panic when I use Latin. I know sometimes in some of the Engelse universities, they kind of panic, but it's de minimis non curat lex. The law is not concerned about small things, minute things. So it's de minimis infringement, doesn't matter, right? That's one argument, or fair dealing. So in the current act, we have fair dealing, general exceptions for protection of literary and musical works. This does get applied. Section 12(1)A and B do get applied to cinematographic works and artistic works, which is our images and our video, and arguably to computer software. So copyright shall not be infringed by any fair dealing with a literary or musical work, but which complies with the following things: for the purpose of research or private study by the personal or private use, or the personal or private use of the person using the work, or for the purposes of criticism or review of that work or another work. So fair dealing. So this is entitled to fair dealing, but it doesn't actually tell us what fair dealing is. So let's look at the definition of fair dealing in section 1. Oh no, let's look at the other exceptions first, sorry. Carrying on under 12.2, irrelevant to us. It's used in judicial proceedings. So LLMs aren't used in that quite yet. 12.3, you're allowed to quote, and this is actually required by the Berne Convention. So are you quoting? Well, what if you quote the whole thing? Well, if you quote an image, don't you have to quote the whole thing? So with literary works, we tend to think of quotations a portion, right? And not the whole thing. But for an image, well, I must cut the image down and then it's quotation and not otherwise, aren't I? So this is talking about just literary or musical works for a moment. Am I quoting it when I'm using it? And if so, do I have a problem? Because I can tell you now that books 3 and Common Crawl, etc., in there do not properly attribute the name of the author if it appears on the work. I mean, if it appears on the work and it's in there in books 3, then it got copied like everything else. But you know, books 3 doesn't say, and the following authors were in this work. It's just like in a copy of the work in books 3, which maybe that's enough. Okay, so maybe this is more tenuous. And then 4, you can use it by way of illustration for teaching. That's got to be compatible with fair practice. How is fair practice different to fair dealing, you ask me? Good question. All right, so if I were an avid AI developer, I would claim that I am training my AI, that I am teaching my AI. Now, do I hear skepticism from you or agreement that I could use teaching and training? You're going to have to take a position on this. For or against? Okay, against. You're not convinced AI is sentient enough to train. The language the developers use is train. I am training my model. Okay, so am I engaged in research? Is my copying okay because I'm engaged in research when I develop an LLM? Why not? Young woman with orange Jersey who's convinced that I'm not engaged in research. Why not? So you don't think that it's fair, it's going to fail fair dealing, or you don't think it's research? Why not though? I'm training an AI. I'm engaged in AI research to develop this model that can do these amazing things. I'm engaged in research. How do we do it? How do we make these things work? But if I'm a developer, but Laura she wants to argue. And you think an LLM is that. Okay. And then once I've got the LLM, okay. So it is arguably research when I make the LLM, but not, because it's not generalizable. It's not systematic inquiry. Yes, but okay, good. Okay. So I argue it is research. But that leaves us with a problem. Is it fair dealing? Because maybe it's research, but it's not fair. The use I'm making is not fair. So we need this definition in section 1. This is the definition of fair dealing in section 1 of the Copyright Act. There isn't one. Yeah, well, so was I when I went to like, wait, hang on, what is fair dealing? Oh yeah, that's right. No, this isn't Microsoft versus Linux. This is the definition. So we don't have a definition of fair dealing. So that is wide open. We can try and fill it with Section 16(1)(c) of the Bill of Rights, which says I have a right to scientific research and academic, what's the other word? I mean, you must all know Section 16(1) verbatim. No? Well, go and read it. Okay, we could fill it with not the section on property, because that begs the question, right? Begs the question of whether copyright is property, and then if it is property, it begs the question of whether it's an arbitrary deprivation. So we're spinning our wheels there. Okay, so 16(1) seems to suggest that it would be fair dealing because we should be engaging in research. First, we have to conclude it is research, right? Maybe it's fair dealing sometimes, maybe it's fair dealing not other times. Maybe it changes if I'm doing it for commercial purposes rather than non-profit purposes. Maybe it changes if I'm using it to generate things that undercut the artists whose work I'm using, but not if I'm using it for another purpose. So imagine I was using it to train an AI not to produce imitative books or text, but to do book recommendations. So it would be a very similar process to training an LLM. It would consume all the books, turn it into tokens, and then it would say, this book is like this other book. Let's assume it can do that fairly well. You enjoyed The Hunger Games, you will also enjoy Divergent. Probably not, because it's not as well written, but like, okay, the LLM can tell you this thing looks like those other things, right? Would that be fair use? So would that be different? I mean, sorry, fair dealing. Would that be different to if you were training a generative AI? Okay. Yes, Murray? Yes, absolutely. Yeah. Okay, so just for everyone, so would it be different if I'm saying an AI, we don't know what AIs can do. We don't know what will happen if we force all the books in the world that we can find or on the internet, lawfully or unlawfully, through this neural net. And so therefore, that's research, because we're trying to find out the capacities of the neural net, what can be achieved. Is that then more defensible as fair dealing? So the fairness piece now, or maybe whether it constitutes research. So it could fall in either camp, but it's not research when you're doing it for, like everyone's done this. We know what it can do. We're not learning anything new here. You're just doing it to make money. I would say that's probably more likely a question, not of whether it's research or not, but the fairness. But it's either way, it's a factor you would have to think hard about. Okay, let's assume you can't win fair dealing all the time. Some of the time, maybe OpenAI could have won it when they first started and they were an actual nonprofit and they were actually open and made their results open. So that's also something that could bear on research. Do you keep it proprietary or do you publish it? So Karl Popper, philosopher of science, is like, it's not science if other people can't challenge it and critique it and try and deconstruct it. He's like, it's not, whether it's good science or bad science in the public interest or not, it's just not science. So on a Popperian view, you wouldn't be engaged in research if you weren't then making everything available, if you were keeping it secret. Okay, remedies. Well, let's say you think there's infringement and it's not de minimis, and you convince the court that your copyright work was used, that it was copied, that it's not de minimis, that it's not fair dealing. What are your remedies in South African law? You can ask for damages. Now you have to prove your damages. These are Aquilian damages. These are actual losses to your pocket, right? So who has done delict here? Hands. Okay, so for people who haven't done delict, in South African common law, Roman Dutch common law, we have categories of claims that you can make. There's the actia do paupery, the most fascinating thing about dog bites and wild animals and fires across land. Not dealing with that tonight, sadly. Then there's the actio injuriorum. This is for harms to the self, so harms to your body, to your dignity, to your reputation. Those require intention. And then there's the Aquilian action, commercial damage, so harm to your body, but that stops you earning a living, or that requires medical. So it's not the outrage of an attack on your body, it's the way it affects you, essentially, that can sound in money. And so, according to the commentators, and at least one case, you need to prove your damage. You need to go, I lost sales. These people sold 100 copies of my book, and therefore I lost 100 sales. Therefore, I should get that money, right? Or you can ask for a reasonable royalty. So you can go, well, I actually do license out my software, and this is the rate, and it gets incorporated in all kinds of other programs, and this is the rate, and so that's what they would have ended up paying me. Or you can ask for special damages, section 24.3. No other damages will do. So exemplary damages. Maybe these people have really, tried to destroy your business model or behaved in a completely outrageous way in some way. Countersued you for copyright claiming they were first. You can get special damages, no ceiling. Pretty crazy, right? There's no ceiling on special damages. Now, not a lot of good cases. So we don't actually know what we could do with special damages. So you're probably going to have to ask for special damages, because you're not going to prove that putting your book in the LLM made you lose sales. How are you going to do that? Okay, you don't need to have done the law of evidence to know you're not going to do that, right? Like, that's too hard. Reasonable royalty. Well, maybe once Elsevier and Pearson start making a lot of money, saying we'll let you look at our whole corpus. So Elsevier control most of the academic journals in the world. But again, that's going to be a pretty small royalty. Firstly, if you, the author, is not getting anything. But okay, maybe your publisher's going to sue, and your publisher not Elsevier. But they can go, look at Elsevier. They let OpenAI, train on this massive corpus of hundreds of thousands of journal articles, and they're getting $1 million a year for it. Well, except what's one article worth in that? It's like 2 cents. 2 American cents, so that's what, like 5 rand? Okay, no, I'm kidding, but like, still, it's not worth it, right? So special damage is your best bet. All right, interdict. You could get an interdict. Stop copying my work. Okay, fine. We'll delete the copy we've got. We've trained the LLM now. What does it matter, right? Somebody else copies it next week, you'll have to get an interdict against them. Delivery of infringing copies or plates used or intended to be used for infringing copies. This is Pamela Samuelson at Berkeley's idea. She's like, because they have a similar provision in the US, she's like, make them give you the model. Bring a class action, which they do more often in the US than here, but we can do here. We just don't do it often enough. And say, deliver up the LLM model to us, the injured parties, so we can stop you, making more infringing uses. So you could ask for that, but I mean, if you're one person, that's not going to work. You're going to need a class action, right? What if all the affected authors in South Africa, you're still going to be a tiny percentage of the people in the world whose works were used. Maybe you can do a class action in South Africa and try and get people from overseas to join. So you're unlikely to get that without a class action. So let's answer the question. Does using pictures, photographs, software, texts to train an LLM infringe copyright under South African law? Who votes yes? Come, let's have hands. Okay, we got some. Okay, who votes no? Okay, who's like, it's complicated? Yeah, everyone, yeah, you can change your vote. So, like, the big issue is, yes, so that is a question we can come to if I go quickly enough. I think my answer is yes sometimes, but this is not a case anyone's going to bring in South Africa. In the US, yes. You're going to get big enough collectives. You've got better financing for class actions, and only a class action. Everyone gets hurt a little bit. No one gets hurt a lot. So how do you remedy injuries where everyone gets hurt a little bit? No individual gets hurt a lot. Where as artists or authors or photographers or software developers, you all get undercut by the thing we're going to talk about next, the production of competing goods. But because that's the real injury, isn't it? Is the injury the copying, or is the injury the fact that this thing now churns out stuff? And of course, one of the questions is what does it churn out? If it churns out stuff that looks a lot like your thing specifically, well, maybe you can claim infringement, direct infringement, because now the output's infringing, not the copying. So back to our fair dealing for a moment. Let's assume that we had fair dealing, but I train an LLM just to produce artwork that looks like Kentridge's art. Okay, now I've targeted one artist. Do you think that's fair? I'm making imitations of his or her work. Easily, kind of intuitively not fair, right? Probably a judge is going to agree with you. Nah, that's not fair. So there's definitely a class of things where you'll never get fairness, because it's like undercut one particular artist, make imitations of a particular artist. Yeah, that's bad. All right. So is there copyright in the output of a generative AI model? How's our time? Okay. So this has been litigated hotly in the US. Leading case, Thaler versus Perlmutter. So Perlmutter is the registrar of copyright in the United States. This is in the District Court for Columbia. And the court is no. Thaler was very clear that he just put a minor prompt in and the AI did it because he wants the AI, in fact, to be named as an author. And the court is like, no, AIs can't be authors. And if a human is not the author, then it's not copyright. So that's our comparison. So requirements for subsistence of copyright in South Africa is original work, material form, but that could be digital data. And you need an author. And so our concern in the Act is all around who are these authors? Are they South Africans? Are they in another country with whom we have a treaty? This is because the Act from 1978. At that time, there were all the Berne Convention countries, which recognized each other's authors. And then there were all the Universal Copyright Convention countries. South Africa was part of both because the US was like, we're not signing Berne. It's got weird shit about moral rights of authors. We don't do that. And they still don't, even though they've signed Berne. We're going to have our own recognition, non-recognition. Right now, my understanding is Laos, Cambodia, and possibly Afghanistan aren't Berne Convention. Afghanistan, I understood, was in the process, but then I guess the Taliban took over again. And so you need an author, but an author is a human, right? They're a citizen or a resident. So our rules of interpretation tell us this is a natural person. This is a human. There's sometimes when copyright can vest directly in a non-human, in a company, a legal person. But legal persons are not in South African law authors. Okay, we're going to look at some cases. Let's start with this warning from a judge in 1995. Computer literacy is not to be assumed in persons over 50, as most judges are. Now, for those over 50 here, we will regard as exceptions. But I think even though that's a long time ago, I think you will probably worry that many judges still don't have computer literacy, as they are not going to have acquired, right? Because if they've been advocates for a number of years, they've used a personal computer, but they have not, done anything other than use a word processor. And then they became judges and they listen to people talk and they use word processors to produce their judgments, and they still meant to have typists to help them. So computer literacy, maybe not. So we start with this problem of originality. So we're going to have two tests. These are objective tests. Is it a work? So is it a literary work? It's got to fall into a category. Is it an artistic work? Is it a musical work? And a work can only be authored by a human being. And these two things can become entwined. And the courts should say, we're not going to recognize works of doubtful substance. So what's doubtful substance? So historically, Anglo-American courts have said, well, we don't care if this is a really crappy picture. Is it original? Doesn't mean, is it like art people would talk about it. This is the most original artwork ever. There's so amazing novel ideas. It just means, did you copy somebody else, right? It's a very low threshold. But even that low threshold has a threshold. Like, no, it's dubious substance. Is there anything here that's like out of the ordinary at all? So you're not asking for creativity. You don't have that high a bar in South Africa, I think, unfortunately. So I'm critical of the lack of a high bar. But we're allowed to say we're not going to recognize junk. Well, that could tell against AI outputs because maybe they're all of dubious quality, of dubious substance, because they don't mean anything. Remember my argument earlier? They are not serving the freedom of expression purpose. So they might be serving a commercial purpose, but they're not serving. So are they entitled to copyright? So in the US, for example, copyright is described as the engine of the First Amendment. It's meant to be serving freedom of expression. Now, of course, we've got a different constitutional dispensation. So, second point, originality. The Haupt case. So they refer to South Africa's 1965 Act, and they say original and repealed act was probably intended to have the meaning it had been held to have in the United Kingdom. There, creativity is not required to make a work original. Save where specifically provided otherwise. A work is considered to be original if it has not been copied from an existing source, and if its production required a substantial or non-trivial degree of skill, judgment, or labor. Right? So it's not just labor. It's not pure sweat of the brow. Locke, sorry, John Locke, all the people who like John Locke's sweat of the brow theory, it's not just labor. We still need skill or judgment. We need something, right? So author in relation to literary work. Sorry, there's computer generated work. So there's a category of computer generated works, and it's inserted into the act through this idea of where it's computer generated, we have an author. He's the person by whom the arrangements necessary for the creation of the work were undertaken. So dubious, doubtful substance. We mustn't have copied. Now, what is the LLM? It hasn't produced a reproduction of the work in its output, right? But it's essentially by weighting all these words that should be next to each other, or pieces of images that should appear next to each other, has it engaged in a substantial degree of skill, judgment, or labor? Well, here's the problem. The LLM is just a piece of software. So have the people who made the LLM engage in substantial degree of skill, judgment, or labor? Let's say yes. That was hard stuff to train an LLM. But they didn't make the output. Somebody gave a prompt. Now, I know people who claim they're prompt engineers and they bring a lot of skill, judgment, or labor to their prompts, but I'm a bit skeptical. Also, you can get good results by just keeping and putting in prompts, right? And Matthew Saga in Emory University in the US says, so, but then that's like saying somebody gets copyright if they pull the lever on a slot machine often enough. You just put in prompts and you go, oh, look, that one, that's cool. So we've got a problem here, because where is originality happening? The engine that produces the thing, we might say, well, yeah, those people deserve copyright in the software of their AI, but that's not the output. The output gets generated by this system without a human being, an author, engaging in any skill, judgment, or labor, which is why we needed to say, well, is it computer generated? But then, like, who is making the arrangements? Is it the people who built the LLM? Or is it the person who enters the prompt? They're the author because they made arrangements for the creation of the work. See, this just wasn't imagined at the time they inserted this thing in 1992. So we copied the British by having this computer generated works. The irony is we're left high and dry because they then all agreed to a copyright directive that is still law in both Britain and Ireland, which implicitly repeals their computer generated law. So we've got this anomalous thing that maybe looked good in 1992, but now looks dated. Like if anybody ever wants to write a piece about technological neutral law, and this computer generated would be like, that looked like it was forward looking, but now it looks like a mistake. Looks isolated because they thought that somebody was going to, sit with a single PC and tell it to print a picture. And that's not what we got. Okay, so helped continues. The Act does not contain a definition of computer generated. So this is not the direct holding of this case, so it's not binding. In my view, a work only qualifies as having computer generated if it was created by a computer in circumstances in which there is no human author of the work. If there is a human author, the work is computer assisted and not computer generated. So hold on a minute. So all of this stuff, like I type and then my laptop does good word processing for me, or bad, depending on what's happening that day. Bad paragraph numbering. Still, we're going to have sentient AI, but they haven't fixed paragraph numbering. Okay, Now, that's definitely computer assisted. So is this AI thing computer generated? Well, it's the best kind of example we have, but it creates a problem. Um, no, pay in again. So this judge was writing about how we had software that could generate these charts. So somebody would type in some data and then the software would put it in a chart. So there was a data entry person. And he says it seems factually wrong to contend that the deviser of the program is the author of the chart. He may have died many years ago. The program may have been bought in from an independent software house. Yet every day, quite different charts are printed out. It was back in the day, printing, right? It's true that the programmer's labor and ingenuity are in a sense responsible for the chart, but in that sense, so are the effort of the designers of the computer itself. For that matter, so are those of the inventor, the barometer, which is needed to get the readings to put in the chart. It's perhaps even more artificial to argue that the operator of the computer is the author. The only skills and labor he has employed is ensuring that the flow of programs and data to the machine is maintained, right? So the judge in Payen would be like, the prompt engineer gets to be the author. No, that's absurd. But the people who created the LLM, they're not the author. They didn't intend that particular work. So even computer generated creates a paradox for us that we don't seem to have a good human author. So how can a work with no human author be original in South African law? We have a problem if we want it to be copyright. And mostly when I presented this to audiences, they were like, well, so we better change the law so we can say the prompt engineers. It's like, no, why should it be copyright? Why should the products of LLMs be copyright? If you think about it for a moment, the incentives for the AI developers, they don't need copyright in the outputs of AI programs. In fact, all the big AI models say, well, we don't want the copyright, you have it if there is any, which we don't care about enough to look into. Incentives for AI operators, right? So you're offering a service. So you've got the same, you're the same as a developer. You're like, people are paying to use Claude. I don't want the copyright in their things. I'm never going to track it all down. And I know that almost all of it's banal crap because I can have an overview of what Claude's producing. So I know it's not worth the copyright, right? Okay, incentives for prompters. Well, that's why I needed a bit more feedback when people were about what you use AI for. Mostly my response from audiences are, I don't need copyright. What do I need copyright for? So if we say we're taking away from authors by allowing at least some training, and there needs to be parameters around that training, then one of the things we can give authors is, well, the output of AI doesn't get any copyright. So if someone wants copyright in a work, I need a logo and I'm going to use it in my advertising campaign and I need copyright so that when my competitors copy it, I can sue them for infringement, then they should pay a human. That seems kind of fair, right? And it's in keeping with the original purpose of copyright law, which is we want to reward authors, human authors. Right? Some of those work for companies and the companies pay them and we don't, pay the author directly, and artists and so on. That's the point of copyright. We wanted to pay artistic people, creative people to do things. We never said we wanted to let someone who puts a banal prompt in get an exclusive right. So South African law could be read right now as it stands to give us that result. So here's whether the should and shouldn't. So my view, some permissionless copying must be permitted with limitations that are fair to authors. Our law is not specific enough to say what those should be and those shouldn't be. We've got no content in fair dealing to do that. We should together enable opt-in curated data sets that reward authors. How can we do that? Good question. That's something I'm still researching. Ideas welcome, right? How can we make it so that there's not just a couple of publishers that have big hordes of stuff that can be used to train things, but other ways of creating these curated data sets that could be like well, now you know there's only human stuff, and then you're going to pay us. Don't know. But we particularly need that in Africa if we want Africa-specific sets. So because of time constraints, I omitted a slide which showed where the data sets are hosted and used. Doesn't 100% guarantee that's where they're from. And it's these little dots, universities and research centers all around the world. Should have kept it in, I can see. There's not a single dot in Africa. So our data might be being used to drop in a bucket. There's a problem too if our data isn't used to create AIs, because that means the AIs don't take our circumstances into account. We need our own AIs, right? We need our AIs in African languages, not English. How are we going to do that? Okay, I think if AI outputs have no copyright, we can just not ever have to fight about whether AIs can be authors, whether they're conscious. Just don't deal. If you want copyright, pay a human author. It's the least we can do if authors are being undercut by these models. And when an author does use AI, there's an argument that they might use AI but also be creative. Fine. Only those elements which they can demonstrate at trial are their human efforts are then copyright. If those are trivial, don't sue, right? Do a factual inquiry. Yes, Marie. Yeah. Yeah. So that's one of the problems. If we try and say AI models can be authors, which Styler is trying to do all over the world, then he's already convinced our patent office that an AI model can be a inventor, which seems a little odd. Then yes, how do you say what's the life of the model? It's that particular model, and when they, yeah, yeah, yes, yes, yeah. Mhm. But then you're in my last point. Only those elements you can prove for your own contribution. Because why should we extend it beyond that? Because three things. One is there's judicial economy in saying, show me, you're saying, well, there could be, and that's one of the problems. I think we should never have just said photographs are artistic works. There should have been a very clear line. Some photographs are artistic works, and here's a set of 10, 6, 3 criteria. So that was a mistake, I think, and thought that before AI. So judicial economy would be, well, we just say no to all of it, except what humans can prove is human creativity, and then there's judicial economy. Then we don't have to litigate all those edge cases. Yes. And you can't afford to pay a starving artist, so we should help you as the starving author. So that's the distributional trade-off. So no, there is an argument. There is an argument. Like, poor me, I have this brilliant idea, but I have been, through no fault of my own, deprived of the ability to draw. True in my case, and I should now. We're overcoming my disability. It's almost cruel to say I shouldn't then get this ability to then become an artist. But it's notice that then we're engaging in distribution. There's a distributional element here. We're choosing me as the starving artist over another starving artist. We're picking one, which is fine, but we're picking one as losers. So first you and then Marie. Sure. Marie? Okay, so what's our time? Okay, so, well, that was the wrap up of what so far. Will the Copyright Amendment Bill make a difference to these issues? As you know, this is going to the Constitutional Court, the whole thing, on, I think it's the 21st of May, sometime in May, for a hearing on whether it's unconstitutional and needs to be sent back by the president to Parliament. President only sent it to court because he just didn't sign it. And then Blind SA said, we're going to bring an action to make you sign it. You're meant to sign things. In terms of the Constitution, you're meant to, the time period in the Constitution is expeditiously and without delay. So we all know that means 6 months. No, we don't. Like, what does that mean when you go to court? But they were like, you've sat on it a year, dude. Like, seriously, sign it. And he was like, no, I don't want to upset the United States Trade Representative. I'm sending it to the cons court. And then it's like, well, in the meantime, a certain president is like, don't worry about upsetting the United States Trade Representative. I'm going to impose tariffs on your country and set a go on fire. So you need not worry about trade pressure with the US for, around IP for the foreseeable future, because it's all about Palestine and whatever else we've done to upset him. So, but does it address these issues? Only partially. So, 12C, any person may make transient or incidental copies of an adaptation or adaptations of work, including reformatting, where such copies or adaptations are an integral and essential part of a technical process, and the purpose of those copies or adaptations is to enable transmission of the work or adapt the work to allow on different technological devices. Well, so this is nice because it lets us make transient copies, which we think we're doing anyway with the internet, but it kind of seems hard to shoehorn. So if my argument was we make transient copies for the internet, and that's got to be okay, therefore, what's the difference between that and scraping the internet to train an AI? Then does this make my argument weaker? Because now we've got the internet's okay, but that stuff, it seems difficult to shoehorn in here. Maybe I could make an argument, but it's hard. Or does it make it stronger? It's recognizing a need for transient copies for technological purposes. So is it exclusio, what? Expressio unius, exclusio alterius, or is it iustem generis? We need more things like this. Okay, fair use. Okay, this is the current fair use rubric in the bill, and this is at the center of a fight that's going to the cons court. So it lists things like research, criticism, reporting current events, scholarship, teaching and education, comment. Lots of these are kind of public interest things, right? And then it says, but it could be anything, such as, so it's not anything, you still have to have iustem generis or nascitur socios. It must look like one of these things. So maybe Laura's claim, this isn't research, and it's not enough like research to be fair use. And then we've got this a factual analysis. So it could be all relevant factors. So our first time could go in here because it's a relevant factor. Are you doing this for the first time? Nature of the work, amount and substantiality of the part of the work affected by the act, purpose and character of the use, including whether it serves a purpose different, does, right? LLM serves a purpose different to the work. is of a commercial nature. Yeah, so just making the model isn't. So do I go, oh, I made the model for non-commercial purposes. Then I started. So the copying was okay because that was non-commercial. And over here, I'm using it for commercial purposes. Do I get away with a two-step like that or don't I? And then purpose and character of the use, so different use, commercial nature or non-profit, the substitution effect of the act upon the potential market for the work in question. That seems right on the nose, right? And so that's our potential replacement for fair dealing. So I don't think this makes it any easier for an LLM to get through compared to the previous, because although it's got a longer list, all these things, the longer the list, the harder it is to say, well, it's not like that, right? Because now you've got to be like research and like scholarship and like comment and like, so that the longer the list, the harder it is to go with a justum generis. Like, it looks like one of those because, okay, but you could probably make an argument because it's anything that looks like these, and you could make an argument it looks like them, like I did, feminist research, right? But we've got the factors, and now the factors seem to militate against saying that just purely training ChatGPT is okay in South African law. But we're going to see what happens in the US. Some of the finest first fair use lawyers in the world are going to be arguing on behalf of Google and Meta and OpenAI that it is fair use. Laura is skeptical that it is fair use in the US. I think it wouldn't survive fair use in South Africa, except perhaps if I were doing something like training a vendor LLM so that it could produce, vendor translations of English legislation or something like that. Otherwise, I think it's going to be hard. Ironically, a lot of the uses I can imagine surviving a fair use analysis are these kind of non-profit governmental uses. Okay, done. Trudy Stellenbosch.
Yeah.
That is appropriate. You couldn't come to
So that isn't any bottle of wine. That is my personal favorite bottle of wine. The Italians have got this grape Sangiovese, which you absolutely must enjoy if you partake. Thank you, Andrew. That was amazing. I like how you wrestled with the act, and it's fascinating. This game that is, this thing that's playing out all over the world of the winners and losers applying old legislation to new technologies. And drafting in a technology neutral way is apparently not as easy as it sounds. I rate the ECT Act quite highly for achieving that. It did not date well on the signature laws, I think, but generally it did really well. Clients of ours recently said that they need to sell their software business because they don't think software development will be a thing in the near future. And we do agreements all the time where we do due diligence exercises and people are asked to warrant that there's copyright in the software, crazy toxic language. And surely there is copyright in the language. Now, if you take those two facts and you realize that maybe, I don't know, 30% at least of any piece of software is completely AI generated, it just underlines the need for certainty. I mean, we need clear policy direction. We need legislation that can catch this and make these things investable. And at the heart of it, I think, is a policy decision. Which way do we go? Do we protect authors at any cost and lose out on the innovation and the incredible power that AI brings? Where do we strike a balance on the continent and specifically here? So thank you so much, Andrew, for coming out. And Sadula, we also want to acknowledge, thank you for the chair to be in attendance and to bring the necessary gravitas to the event. Thank you very much. Thank you all. Thanks a lot. Yeah.